Hi, I don't know if anyone's watching us though. So anyway, let's just get started. I'm Colleen Blanchard. I'm from the Itasca Library. I'd like to thank everyone for coming to our Zoom presentation tonight for wills and trusts. This is all new to us. It's all new to you, but you get to see everyone, the inside of everyone's houses, which is the fun part. We have other programming on our website. We've got a lot of creative stuff coming up. If you'd like to join any of our webinars and or meetings, please look at our website and feel free to join. Tonight we have Lisa Knauf and John Pancaw. John is joining us from Florida. Isn't this great? We can be anywhere in the world.
That's right.
And Lisa is joining us from Madison. Lisa and John have both presented at our library before, and we invited them back to discuss wills and trusts, especially in this time of where everything's up in the air and changing. So here's Lisa Knauf.
Thank you, Colleen, and thank you to the folks at Itasca Library. This is, I think it's great that you're being creative and letting your patrons participate in programs when they can't leave the house. So as Colleen said, John and I have an office in Addison on Lake Street, not far from the Itasca Library. And our practice is focused on estate planning and real estate and a couple of the other topics that we're going to talk about tonight. As you can imagine, with the current health situation, the current COVID situation, having a will and a trust and doing estate planning is, and healthcare directives is really a topic that a lot of people have concerns about. And we've been busy answering a lot of questions from clients and people in our community. So tonight we're going to talk about some basic topics. We're going to talk about what is a will and a trust, what is probate, powers of attorney, what is joint tenancy, and we're going to touch a little bit on the process that, like many providers and businesses, we're adjusting under the current restrictions, the current stay-at-home restrictions, and as we know today, Governor Pritzker extended our stay-at-home until the end of June, or until the end of May, so we are changing as the climate changes. So I'm going to do a little bit of level setting and explain what these documents are, what are the parts that make up an estate plan. And John's in Florida. It's a little warmer there than it is here in Illinois, so he'll chime in and assist me in doing some explanation. First, let's talk about what is a will, often called a last will and testament. A will is really just a set of instructions. It identifies who you want to inherit, the things that you own, your personal property, your possessions, your clothes, dishes, jewelry, and your financial assets. The people who inherit those things could be the same or different people. A will can be a fairly simple document. It's inexpensive to file. We are required by state law to file a will 30 days after we find out that someone has died, or someone who's previously died and we find out that they have a will. It's been a little bit of a challenge here during the COVID-19 situation. In Illinois, you need 2 witnesses that must see the person signing the will. That's a testator, if it's a male, or a testatrix if it's a female. And the witnesses must see the person sign in their presence. So Illinois has passed a temporary electronic signing statute. It has provisions that will cover us for the next 4 to 8 weeks, but it's a little bit challenging, especially for some of our older clients that don't have high-speed internet, that don't have camera capabilities. The statute allows someone to sign the papers that we send to them, but we have to have a video ability to watch them sign the document. And then they have to return them to us to be witnessed to within 24 hours. So one way around that is we're offering what we're calling curbside closings or curbside signings. And our clients can pull up in their car outside the office and we will come out with witnesses and watch them sign. And down in the lower right corner of my slide is a picture that one of the tenants in our building took a picture of us as we were helping a client sign their documents from their car. People often ask, if they have a will, does that mean we have to go through probate? I'll talk about probate in a minute, but a will is only good after you die. It's no good if you become incapacitated. And It doesn't cause probate and it doesn't replace probate. In Illinois, if you have $100,000 or more in assets or you own real estate, you're required to go through probate. So having a will is really what I said earlier. It's a set of instructions for who inherits the things that you own. And all heirs must be notified when you have a will. And a spouse can renounce a will. So if you're trying to disinherit a spouse through a will, especially after being locked up at home for 2 months, there's probably a better option than using a will. And we don't do criminal law, so I would have to refer you to a colleague if your stay-at-home situation gets worse. So what is probate? Probate is the court process of settling somebody's estate after someone dies. And as I mentioned earlier, in Illinois, if you have $100,000 or more, we're required to go through probate. So it's a long process. It takes a minimum of 6 months and usually closer to 8 to 12 months. By the time we file a petition with the court, we go through a 6-month claim period and then do some accounting and distribution at the end. The legal process of probate makes sure that the will is valid, make sure it was validly executed, make sure that your debts are paid, that person who passed away, their debts must be paid, and then the assets gets distributed according to your wishes. So the good thing about probate is that at the end of it, when people inherit, we know that there can't be a claim against the assets that they've inherited. So it is useful if people have a lot of debt, or if we're not sure that if the person who died, if we're not sure that there might be claims from employees or lawsuits that perhaps the family's not aware of. As I said, it takes time, 9 months, could take 2 years. I think John had one that took 5. The more people fight, the longer the process takes. It is public. Court records are open. It's public record. Who's inheriting, how much they're getting, who the heirs are, if someone's been disinherited, and it's easy to contest. If someone doesn't like the distribution instructions in a will, then they can file a simple document and challenge the will. As I said earlier, in Illinois, if you have an estate that's valued at $100,000 or more, we're required to go through probate. If you own real estate, it's usually required, and probate is actually probably the best process of transferring real estate if we want to make sure that the buyer is getting what we call clean title, that there isn't anybody or anything filed against the title to the property. We recommend probate if there's a lot of debts, if the executor doesn't know the extent of the debts, or if there's a lawsuit or claim that we want to make sure gets resolved before the heirs receive any distribution from the estate. So what's going on with probate in the current COVID-19 situation? As I said today, the governor extended, as most of us know, he extended the stay-at-home order, and all our courthouses are closed. Only emergency matters and necessary matters are being heard in court. Depending on the county, for probate in particular, the remote solutions vary. The far outlying counties will allow us to do it by mail. We call that over the counter. We can mail documents in and get orders signed by a judge. But in the big counties like DuPage and Cook, we're very much delayed, and especially in Cook County, we have not been able to open or close an estate in a couple months. So when you add on the required time period that a probate normally takes in a normal time, we're anticipating lengthy delays in getting estates settled, unless of course there's an emergency situation. And what is an emergency situation? That's an evolving definition too. Having to sell real estate, is that an emergency? It's kind of up to the judge, and that's the conversation that John and I have been having with our fellow practitioners. So how do we avoid, people call us often and say, John and Lisa, you're nice people, but we don't want to go through probate. We want the things we own just to go to the people that we want to inherit. And one way to do that is through a trust. A trust, the most common kind of trust that people ask us about is called a living trust, a revocable living trust. You set it up while you're alive. It's changeable. You can modify it while you're alive. It can help you avoid probate because it allows you to change the ownership of your assets, like your house and your bank accounts. And that $100,000 threshold for probate does not include assets that you don't own in your personal name. It allows you to choose someone of your liking, of your someone that you trust to oversee your affairs. It's private, which is one reason we really like trusts. We like the privacy of them because they typically don't end up in court unless, of course, there's litigation, and then all bets are off as far as that goes. But where we're really seeing, especially right now in the current situation, is during incapacity, or if people are unable to manage their own assets, when you set up a trust, you name trustees or successor trustees, and we're finding that some people that are older or in ill health are able to delegate the management of their assets to their successor trustees if they've got a trust set up. So this is something we've had several conversations about over the last few weeks. And it could minimize a possible will contest, minimizing potential challenges to the distribution of the things that you own.
Lisa?
Yep.
Let me add something. On the portion that you had on the will, you mentioned renunciation by a spouse. And one of the things that allows the spouse to do is to make a statutory claim of 1/3 or 1/2 of the decedent's estate if they're married. And a lot of times in a second marriage, you don't want to allow that to happen. So one of the advantages of a trust is that a spouse cannot renounce a trust. We had a case a number of years ago where the person deceased, the lady deceased, and we advised her to get a trust, and she insisted on keeping her will. She got remarried and then passed away, and her husband was able to claim a full third of her $1 million estate. And of course, she had wanted everything to go to her 3 kids. So through the use of a trust, a spouse cannot renounce a will, cannot renounce a trust. And therefore, you can have the children receive the entire estate, and the spouse cannot claim any portion of it. So that's one of the advantages where you had that portion you were talking about, lessens family conflicts. So the use of a trust really, really comes in handy there. Sorry to jump in on that.
No, thanks, John. That's a good point. A lot of people come to us, and we have this conversation, John and I do. How do we minimize fighting? How do we avoid conflict? And that's a very good point about, in particular, a second marriage situation. A testamentary trust it's a little trust. It's a baby trust that we can put inside of a larger document, a larger will or trust. And this is really useful when people want to leave money to their grandchildren, to minor children. It allows you to set money aside for education, for school, and avoid having a lump sum distribution to a young child or somebody who has special needs, someone who has substance abuse issues. So we do a lot of testamentary trusts, and they're very useful. You can, John, I think you did one for somebody who was setting up a lake home and setting money aside to take care of a place that was special to their family.
Yeah, the one that Lisa's talking about was an elderly couple that had one daughter, and she wanted, the mom and dad wanted to make sure that their lake house up in Wisconsin was preserved for their grandchildren and great-grandchildren, because their concern was their daughter would immediately sell the property upon the parent's death. So they set up their grandson, who was at that time in his 30s, as a successor trustee. And in fact, they set up 3 testamentary trusts. And one testamentary trust was solely for the home up in Wisconsin, and that got titled into that testamentary trust, along with about 200 grand that they set aside to take care of that home up in Wisconsin. And then they set up a educational fund for all of the great-grandchildren that allowed all of the great-grandchildren to go to college for 4 years if they chose to. Actually, it was a period of 5 years after the death of the grandparents. So it provided for 5 years full education, and then the balance of the money provided for the daughter, 2 grandchildren, and 4 great-grandchildren, the 7 of them, $25,000 a year until the money ran out. And they had a total estate of about $2 million. So those 3 testamentary trusts, 2 of them are still in existence. The education trust is gone because Grandma and Grandpa have been dead for more than 5 years. But the lake estate the lake house is still in existence, and there's still money paying 25 grand a year to all the 7 participants. So it was a nice way to provide money, and it was not a huge windfall, but $25,000 a year, especially now, would really be nice. So that's a nice way of setting up a testamentary trust. I'm sorry, go ahead, Lisa.
No, thank you. I think that's a good example. And some people might be thinking, well, I don't have $2 million. I don't need that. But even if you have life insurance that's worth $100,000, $200,000, you probably don't want your young children to have access to that money right when they turn 18. You could delay it and use it for school or a trade school or starting a business or something. So it really is a way for you to exercise a little bit of control after you're gone about what happens to the money. Land trusts, they're a special kind of trust. They're only good for real estate. They are held by a third party, usually a bank or a title company. Chicago Title is a large title company. They have a very big land trust department. They're not every state has them. They've been in existence in Illinois for a while. We're starting to see more of this kind of trust because of the privacy. If you title your home into a land trust, when it's looked up on public record, they only see the land trust number 1, 2, 3, and it's a little bit harder to find out who owns the real estate. It's also a way to you can name a beneficiary on a land trust and transfer your home or your property to other beneficiaries, again, without going through probate. So we're seeing more of them primarily because of the privacy issues. And then this is a certain kind of trust called a special needs trust or supplemental needs trust. These we use for families that have a disabled child, a disabled spouse. What it does is allow you to set the distribution aside into a fund to be held for the person's benefit. The most important thing is that it doesn't endanger the government benefits. If a disabled person is on Medicaid and they are receiving benefits, disability benefits, inheriting money may cause them to lose their benefits. So this allows you to set some money aside for educational opportunities, a service animal, maybe a vacation, or to fund a hobby that the government benefits or supplemental benefits aren't going to pay for. As our population ages, one part of our practice is working with our clients as they plan for the possibility of going to a nursing home. And if a spouse is in a nursing home, one spouse in a nursing home and one spouse out in the community, if the healthy spouse dies and the spouse in the nursing home inherits all of the assets, then that money has to be used to pay for the nursing home. And sometimes if they're receiving disability benefits, again, they might lose their benefits. So it is a way really to set up some money to provide primarily for a disabled family member. And then we have pet trusts. Pet trusts are legal in Illinois, And pets are part of our family. A lot of people ask us, what happens to my pet, my cats, my dogs, my horses, when I pass away? Who's going to take care of them? And a pet trust will let you do that. Just like setting money aside for young children, you can set money aside during the life of the pet. You put somebody in charge of taking care of the pet, and the money will help pay for their care, for veterinary care. And if you have a pet now and you buy more pets or acquire other animals, the pet trust can provide for any animals that you might own at the time of your death. And dogs, horses are expensive pets to take care of. And when you ask somebody to take care of them, being able to leave a little bit of money for their care, I think, is a great way for you to take care of these parts of our family. So I want to touch for a minute on a few other estate planning options. This is relatively new in Illinois. The law was passed in 2012 and updated in 2013. John and I do a lot of these. It's called a transfer on death instrument, or TODI, T-O-D-I. Similar to putting a beneficiary on a bank account, TOD, transfer on death. This allows you to put a beneficiary on a house, on a piece of real estate. Here in Illinois, it's only good on residential property up to 4 units. We can't use it on commercial property, large multifamily, and you can't use it on vacant land. It's a document that has to be witnessed and notarized and recorded with the county prior to the owner's death. So the owner must be alive at the time the document's recorded. But when the owner passes away, title transfers automatically at the death of the owner. And the law now has been in existence for long enough that the title companies have had time to see the transfer, make sure that they can insure the title to a buyer. And when the primary asset in an estate is the family home and maybe some retirement accounts, putting a beneficiary on a house is a really great way to avoid having to go through probate or some other possibly more expensive method of transferring the family house or your primary residence. So a small estate affidavit, the law now provides for us a way to settle estates without going through probate if the person who died had less than $100,000. So in the example I just used, if we have a TODI that transfers the family home to the kids, and we have an IRA perhaps with named beneficiaries, maybe we have a checking account or savings account for $5,000 or $10,000. A small estate affidavit can be used. It's signed by a family member or possibly the person who's named as the executor in the will, even though they don't have court authority. They can sign an affidavit. It allows us to liquidate those small assets, transfer them to the people who are supposed to inherit without the requirement of going through the probate process. The one caution is that the person that signs the affidavit, they're liable for making sure that that money is used to pay the decedent's debts. So we do have to list on the affidavit if the person owes money to a credit card or a mortgage or any other debt. And the affiant, the person signing, they basically promise to pay those debts before they distribute the money that they're getting out of the account.
Can I jump in for a second?
Yep.
Going back to the where you said make sure there are no disputes, and it says can I use it if there are disputes? That ties into the TODI. On the transfer on death instrument, it's extremely important to make sure that the beneficiaries that you list under the TODI are going to get along. Because if they don't agree on everything, all it takes is one of the persons that's a beneficiary to disagree, and then all of a sudden you're ending up in a court dispute. So a lot of times you'd say, well, my kids will never fight, well, or my beneficiaries will never fight. But we've had 2 cases now where the beneficiaries have not always agreed on what to do with the real estate. and it can make it a much, much more expensive transaction. So a lot of times it's easier to go through probate or to set up a trust. So if the TODI works wonderful if everybody agrees. So that's the one caveat you've got to say on there. So, and the same thing on the small estate affidavit. Any disputes, and then that you end up in court. So the bottom line is make sure that everybody's going to be in agreement on everything.
Thanks, John. That's a great point. And John's right. That's on our checklist of questions to ask people when we talk to them about a TODI is, can they get along well enough to sell the house? Because if not, it may be cheaper and faster to go through probate and have an executor appointed. And John's right. Probate sometimes gets a bad rap. It has a bad, let's say, reputation. But the nice thing about probate is an executor is appointed, and they have the authority of the court to sell the real estate, pay the debts, and disperse the money. These items that we're talking about, the TODI and the small estate affidavit, are outside of the court process. So they're not the best solution if you think that there may be some dispute after you're gone. So thanks, John. That's a good point. So joint tenancy, people ask us all the time, well, if my kids are joint on the house, if my kids are joint on the bank account, when I die, they'll just own the property, they'll own the bank account when I die, and we don't have to worry about probate or anything else. And that's true. So joint tenancy is the ownership of an asset by 2 or more people with right of survivorship. So if 3 people, 2 die, the survivor owns 100% of the asset. So it might work well between spouses, but if you are joint with your spouse, at the death of the second spouse is when we sometimes see a probate, because the surviving spouse now owns all of the assets. John mentioned earlier about second marriages, and in a blended family, if everything is joint between the spouses, the surviving spouse can change their will and leave everything to their own children, as opposed to equally between the children of both spouses. And I think that's on our next slide, is joint tenancy. Yeah, joint tenancy with children. So I had a lady call me last week. Her husband passed away not too long ago. And the first thing she did was she went to the bank and put one of her 4 children as the co-owner on all of her bank accounts. And she said to me, well, I know that that child will do the right thing and share with the siblings when I'm gone. But John and I both know that that doesn't always happen, and that's the hard part. If you and one of your children is a joint tenant on a bank account, by operation of law, that child owns the asset at your death, and they don't have to share it with the other siblings if they don't want to. And they can talk to any other lawyer about that, and they will own it. So that's a steep hill to overcome if you want to be sure that the things you own go equally to your kids. The other downside is, and this is a big problem, I have a dispute right now where the asset is joint with a parent and a child, but the child's being sued. It's possible they're going to have a judgment against them, and because they co-own the house and they don't live there, it's considered investment property. So part of the value of that home could be used to satisfy a judgment or part of a bank account. So you have to be very careful about who you're adding on as co-owners of the things that you own. Gifting.
Lisa, can I, Lisa, on the same thing that you've got on the tax negatives on gifting also apply to the joint ownership.
Yep.
So one of the biggest things that you have when you put a person on as a joint owner on an asset that has appreciated in value. It's like a piece of stock. Well, they remember when they used to go up. So, but the person gets the asset at what you paid for it. So if you paid $100 a share for the stock, and now it's worth $200 a share, but you put them on as a joint owner, they get your tax basis in that piece of asset. So their asset basis is $100. If they sell it for $200, they have to pay the capital gains on it. If they inherit the asset, and this applies to gifting too, if they inherit the asset, they inherit the asset at its step up in basis or date of death valuation. So joint tenancy and gifting are a huge way of having a huge tax negative to whoever you put down as a joint owner or whoever you gift the asset to. So be very, very careful about where you list the owners as joint owners, because it can negatively impact the person on their loss of capital gains. So be very, very careful on that. Go ahead.
Yeah, no, thanks, John. I was going to mention that, especially about real estate. We're talking about joint tenancy with real estate. If you own a home, like John said, and you add your child on as a joint tenant or a co-owner, you're giving them part of the home, basically, but you're giving it to them at your cost basis. So the better option would be to use a trust or the TODI that we mentioned earlier and allow the children to inherit the home at the current market value, as opposed to being joint tenants, because when they sell it, it's possible that they're going to have capital gains. And the way that works is if your parents spent $50,000 on their home and it's worth $250,000 when they pass, if you inherit it at $250,000 and you sell it at $250,000, that's tax-free money. You won't pay the tax on that appreciation in the asset. So, and hopefully the stock market's going to go up and we're going to have this problem or issue with our stocks and our other assets. So gifting is if you're putting your assets in someone else's name or adding them as co-owners, you lose control of the asset. There's definitely possibly some negative tax consequences, as John mentioned. And in the future, if you go to a nursing home and apply for Medicaid, Medicaid currently is the only government program that pays for long-term care, you may be penalized because you transferred assets for what we call for less than fair market value. And the state of Illinois says if you gave away all your money, then you're going to have to wait for a period of time before the state will agree to help pay for your long-term care. So it can have a huge negative effect on your ability to defer taxes and possibly qualify for aid in paying for long-term care. So before we wrap up tonight, I want to take a couple minutes and talk about powers of attorney. A power of attorney it's a legal document that lets you name somebody called an agent to act for you on your behalf. Now, a will is only good after you die. Powers of attorney are only good while you're alive. We use them for healthcare, we use them for financial and legal decisions. And if you don't have either or both of these documents and you're unable to make decisions, then what happens? We have to go to court and have somebody appointed to be your guardian. If you don't have anybody, then the court will appoint a public guardian to act on your behalf, and that might be somebody that you don't know or that you wouldn't choose to act for you. Getting a lot of conversations about healthcare, powers of attorney, and advanced directives over the last couple of weeks. The healthcare power of attorney lets you appoint someone who can make medical decisions. They can talk to a doctor, they can select a facility, authorize treatment, if you're an organ donor, or they can arrange for the final disposition of your remains if it's your desire to be buried or cremated. Where we really see this coming into play is end of life decisions. If you don't want to be kept alive on life support, or you do, if you don't have somebody that you've appointed to make that decision, then there might be other people that make those decisions for you. Picking a facility and just the ability for someone to speak to a doctor on your behalf and gather information. Power of attorney for healthcare is really important. I see you unmuted, John. You want to jump in?
Yeah, I was going to mention, when you've got the powers of attorney, a lot of times it's a good idea to make sure that you're choosing the best person that's going to make the best decision. Don't necessarily have to go with, you know, my oldest child, or, you know, you want the person that is going to be making the decisions that you want made. And it's possible you can have one person as a power of attorney for property and another person as a power of attorney for health care. But if there's a disagreement between the two parties, the power of attorney for health care is the one that will make the decision. We've had a couple of disputes on this, and the one that I remember in detail was where the power of attorney for property was the son, and he wanted the parents to continue to live in their home, and there was sufficient money to take care of them. And his decision was, we're going to have mom and dad live in the home. We'll have somebody come in, and we can pay for it. We've got the money. The sister, who was the power of attorney for health care, said, no, we're going to be putting them into a institution or into a health care facility. And they ended up splitting them up in the health care facility because mom had some forms of dementia and the dad didn't. And the health care agent was the one that ended up being able to make the decision, and the power of attorney for property, all he could do was just pay the bills. So make sure you're selecting the person that you want and that will follow your direction, not just somebody like I have to appoint my oldest son or daughter or something like that. It's very, very important. I'm sorry. Yeah. Go ahead.
No, that's a great point. And a lot of times I'll ask people, are one of your children a medical person, or who lives the closest? Who goes with you to the doctor now? You might want to have that person, like John said, even if they're not oldest to youngest. And we encourage, if you look at the standard forms you can find online, there's a spot for a primary, but we encourage people to name 2 or maybe even 3 backups in case something happens to the first or second person that you've named. You've got backup people on there, because if you're unable to sign a new document and there's nobody else appointed, then we're kind of right back where we started with having to have a court appoint somebody. The other power of attorney, called a durable power of attorney or power of attorney for property, allows you to appoint somebody to make everything other than healthcare, financial and legal decisions, anything to do with money. So banking, real estate, stock transactions, authorizing IRA distributions, and planning for long-term care or asset transfers. Right now, we're seeing a lot of use for people that I've got a couple of high-risk seniors, clients that can't leave their home. They have a power of attorney for property. They can allow their family members to go to the bank for them and help them with their finances. Illinois has also allowed us to do some remote witnessing and notarizing electronically. Again, we're having a little struggle with this with clients that don't have the internet and video technology that's required. So we are also offering curbside. People can pull up in their car, stay in their cars, sign the documents. We review them on the phone ahead of time. They sign only the signature pages. We watch them witness it through the car windows, and then they leave. They don't have to get out of their car. We bring the documents back into the office, sign them, let them sit for a few days in case there's any I don't know, virus on the documents, and then we can package them up and let the family come pick them up. So this will let people talk to you and transact business for you.
Lisa, Can you go back to that previous slide on the property one?
Yep.
One of the things, yeah, on that one, you notice in there authorizing IRA transactions and gifting and Medicaid planning and asset transfers, digital assets. Those are not in the standard power of attorney. So people often ask Lisa and I, gee whiz, can't we just get those things and download them and sign them right off of the internet? And the answer is yes, you can, but they don't have all the things that now are needed to make a good power of attorney viable. When the state legislature did this power of attorney, we weren't even talking about digital assets or IRA transactions. So the legislature does not keep up with all the changes in the law. And so that's why it's necessary to go and get somebody like Lisa or myself to do these things for you and to do them properly. Otherwise, you may have one and then find out it doesn't do what's necessary to get done.
Mm-hmm. Yep. Thanks. Yeah, it's a good point. And people, and this goes for wills too, downloading documents and making sure they're witnessed and notarized properly, and making sure that your wishes are carried out. Sometimes the standard package ones you buy at the office supply store don't always do what you need them to do.
Yeah, we had a situation. I was going to say we had a situation where they did the will. They did a will package off of the internet, and because when the gentleman's family drove it up for him, they inserted his girlfriend's name where they should have put his daughter's name. So where he was gifting money to his girlfriend and then splitting the remainder of the money between what he thought was his children. It was his girlfriend and his son, and all of a sudden the daughter got left out. So you have to be very careful, and you have to read these things too. You know, so it's an important thing. So bottom line, you know, get a professional to do these things for you.
John mentioned digital assets. I just have a couple slides on digital assets. Colleen, how are we on time? I have about 7:45. I'll run through these couple slides, and then if we've got some questions, we can go ahead and ask them.
So yeah, we have plenty of time, Lisa, and
Okay.
I did want to mention, if you have questions, anyone in the audience has questions, you can type them into on the bottom there where it says Q&A. If you click on that, you can type in your questions and then we can read them to Lisa.
Okay, thanks. All right, I'll just touch on digital assets, and all of these people who are Zooming from home and working from home and storing their documents in the cloud have probably a better appreciation of what a digital account and asset is than maybe they did just a month or so ago. A digital account is anything you access with a user ID and a password. So it could be email, photos, social media, Twitter, Facebook, any of the online, Instagram, any of the online accounts. But a digital asset it's not just Facebook. Back when John and I first started talking about this, he said, I don't have Facebook. I don't care about digital stuff. But then we started talking, and we have a website, and we have files stored in the cloud, and resources. So bank accounts, music, movies, lots of things. So a digital asset is something that has value. Could be sentimental value, it could be financial value, that you want to either leave to somebody, or you have certain instructions that you want to have happen with that after you pass away. Could be a draft of a book or a journal, a blog. John and I were presenting a couple years ago and a lady raised her hand and said, what about genealogy research? She said, I've spent a ton of money and time researching my family history with photos and documents. Is that a digital asset? It means a lot to her. She spent a lot of money on it, but that's true. If she dies and no one knows it's there and can't access it, then that valuable information might be lost forever. So family photos, I've had a lot of people tell me they're spending this time while they're trapped at home, digitizing their movies, scanning their family pictures, and where are you storing those? and how is somebody going to find them? So as part of your overall estate plan, making a list of the accounts that you have, what the passwords are, where they're located it's a part we forget about because we can go to the bank and the brokerage account and we get statements, but some of these other things are so important from a sentimental perspective, financial also, but also sentimental. Who's going to find them? Who gets them? What happens to them? And what's going to be done with them after you're gone? So on one of my previous slides, I had an icon for a product called LastPass, iPass, KeyPass. Those are password vaults, they're called. There's lots of them online. It's a place where you can store your passwords, and you can put them on a spreadsheet, you can put them on a piece of paper, but wherever you store your passwords, make a note in with your will and your trust and your other documents so that when you're gone, somebody can pick up that book or that package and have the password or the key to your password vault or the list of passwords, as well as who your accountant and your attorney and your investment person is. It used to be just kind of a, oh, by the way, part of our estate plans, but it's really becoming so much more important than it was, 10, 15 years ago. And without passwords, as a lot of us know, if you watch the news, if somebody has a phone and we don't have the password, we can't get into it. They can wipe it clean. But if you want data or information off that phone, having the password to the phone or the computer could be critical in maybe getting information that's important to you after somebody's gone or if they're sick. So just to sort of summarize, the three key components of an estate plan, regardless of how much you own, is a will, which is that set of instructions, power of attorney for healthcare, and a power of attorney for property. That's the three legs of the stool. Then adding that is we might need a trust, depending on what you own. If we have people to take care of, the reasons we talked about earlier, pets. Do we want to put a beneficiary on your house? Do we want to set up a land trust? The other pieces, those are important, but these first three components are essential. So if you have nothing, starting with those three, at least will provide a good foundation for your family and those that you care about. I have there's a couple of really good books out there, and the ABA is the American Bar Association is the publisher of one, and it's a short book on putting together a list of, it talks about what a special gift it is for your family to have your information and your contact information all in one place for your family after you're gone. And it makes their life so much easier when they're struggling with losing a loved one without having to add on the frustration of where is everything and how do we pay their bills and worrying about missing an asset that might be important. And when do you need to update your plan? We advise every 3 to 5 years, pull it off the shelf, the nice binder that we gave you, dust it off. Has someone died? Have they moved away? Have you been divorced or someone else in your family's been divorced? Do you have new kids, new grandkids? Have you remarried? Purchased property out of state? You have a spouse or family member who might be going to a nursing home? These are times really to take a look at it, at least review it, if not update it. We don't charge for our initial consultation. We encourage clients to come in with their old documents, have John or I take a look at them, at least to see if they're current and that your wishes are reflected properly. That's the end of the slides that I have. John, I see you're unmuted. Do you want to add to my summary there? No? Okay.
We've had a couple questions, and I think Nick is going to handle them.
Okay.
Hi. So we have a question from Kelly, and these are also answered by John. But if you want to add your own answer to. Can I still do a trust for my house even though I still have a small mortgage on it? And John said, yes, you can place the house into a trust. Any other advice?
Yes, that's correct. I'd probably say the vast majority of people don't own their homes free and clear. So putting your house into a trust changes the ownership of it. It changes the ownership from you as an individual or you and your spouse as individuals to the trust with you as trustees. So you still own it. It's still subject to the mortgage, which is a lien on the property, but it is now subject to the terms of the trust and who who would take over after you die or who inherits after you die.
And another one, if you name beneficiaries on your bank accounts and other investments, do you still need a will or trust? And John says that our suggestion would be yes, since you would want to have your personal property divided the way you want. You probably would not need a trust, but we would suggest a will and powers of attorney.
That's right. The powers of attorney are only good while you're alive. So if you've named beneficiaries on your accounts, that's a great way to avoid probate. It's a great way to have those assets transfer to the people that you've named. But those people have no ability to assist you while you're alive if you're incapacitated or if you're sick. So John and I are big believers on powers of attorney. We include them in all of our estate planning packages because they are just so important. And having a TOD or a beneficiary on an account doesn't do anything for letting that person assist if you're still alive. And you still need a will even if you have beneficiaries, because there's things that you own that you can't put a beneficiary on, like your wedding ring, like grandma's rocking chair. And people fight about money all the time. We see a lot of it, unfortunately, but people fight over sentimental items. Money's math. If you leave your estate 50-50, we do the math and people get 50-50. They might not be happy, but we can do the math. But we can't chop up wedding rings and grandma's gravy boat or the rocking chair. And so having those in your will designated to certain people, if you've promised them, will go a long way to avoiding family conflict. Even if we never go through probate, having wishes in your will is really important.
Okay. Another question. What was the ABA book that you mentioned that helps put all your information together?
And now I'm going to draw a blank on the name of the book. It's called, do I have a copy of it here? I can put it on our Facebook page. It's, darn it. It's like creating a plan for the family. I'm drawing a blank on the exact title. I'm sorry. And here I am talking to the people from the library. Can I get back to you on that? I can put it on our Facebook page.
Yes,
or I
of course.
can give it
Yes.
to you. Do you remember, John, what the name of it is?
Oops. No, I don't. I don't have it.
Okay. All right. I'm sorry. I think it's creating a plan for the family.
It was a really good one, though.
I can Google. I still have to
I
Google
think
it. It's
that's
on
all
the
the
ABA
questions we
website.
have right now.
Well, that's all the questions we've had. Does anyone have any last questions before we end this wonderful meeting today? Nope. I
No.
want to thank Lisa and John for opting into this experiment of ours. We're going to have a lot more presentations coming up over the next couple of months while we're all staying home. And we hope you will join us again. Thanks, Lisa. Thanks, John.
Thank you, Colleen and Nick and Carrie. We appreciate the chance to talk to your patrons. And I think, are you going to put this on your website if people missed it tonight? Could I direct them
Yes.
to the library website for other programs?
Yes, thank you for mentioning that. This is being recorded and it will be put up where people can view it. We'll probably leave it up for about 2 weeks.
Okay. All right. Thanks so much,
Everybody
everyone.
stay
Stay
well.
healthy.
Bye. Thank
Bye-bye.
you.
Goodbye.